Stefanski. I'm a partner in the Milwaukee office. I am in the Insolvency PSC. My practice primarily consists of commercial litigation, real estate litigation, insolvency, workouts, and dispute resolution type matters for financial institutions and commercial clients. So I'll be presenting along with Yana Vladmirova. Yana, do you want to give a brief introduction?
Okay. Hi, everyone. I'm Yana Vladimirova. I'm an associate in the Madison office. I also focus my practice on insolvency matters and collection work.
Today, Yana and I are generally going to cover what we typically do after we've obtained judgment on behalf of one of our clients. We are both based in Wisconsin, so we'll be providing guidance under the options typically available to us here, but most jurisdictions will feature very similar options for judgment enforcement and collection. So if you have any questions about a particular jurisdiction, you can certainly share them with us or directly with one of our attorneys in that particular geography. Quick note, we will not be covering lender liability, foreclosures, replevins, UCC sales, creditor representation or in bankruptcy or receivership, as those have either already been covered in this series or will be covered by separate presentations. To go along, we're happy to answer any general litigation questions you may have. We're going to focus today on the legal effect of judgments and how we typically go about collecting them. Here, we'll be offering, in general, the perspective of our clients. If there are financial institutions that were secured, we'll generally be talking about pursuing recovery on a judgment after we've already recovered on any collateral that was securing the indebtedness, or just from the perspective of general judgment creditors after we have obtained judgment against the debtor. And so just in terms of terminology today, when we're talking about judgment debtors or debtor, what we're referring to is the company or defendants against whom the judgment has been entered. Yana, do you want to talk about what we do when we're docketing the judgment and the effect of docketing that judgment?
Sure. So the first thing to do once you have a judgment, at least in Wisconsin, is to docket your judgment. Why is that? Because once docketed, the judgment becomes a lien on all real property of the judgment debtor in the county where the judgment was obtained. So to do that in federal court in Wisconsin, once entered, the judgment actually becomes a lien on all real property of the debtor in the county where the district court presides automatically. There is no additional step to be taken to docket the judgment in federal court. However, for state court, to docket the judgment in state court, the judgment creditor basically has to pay a docketing fee, after which the judgment appears as a lien against any real estate owned by the judgment debtor within the county where the judgment was obtained. So if the debtor owns property, however, in multiple counties, that judgment will need to be docketed in each county in which the judgment debtor has property in order to have a valid lien on the real property. For small claims, to docket a small claims judgment against real property, there is one extra step. The plaintiff must obtain a transcript of the judgment from the clerk of the small claims court and then file it with the clerk of the circuit court. The judgment lien is effective for 10 years, after which the judgment creditor can extend that period for another 10 years. And the docketing of the judgment does not serve as a lien on personal property. This is just for real property. And finally, as I said, this only applies for real property. This only applies for real property in the county where the court presides. If you want the judgment to become a lien in other counties, the judgment creditor must obtain a transcript of the judgment, pay a fee, usually a filing fee, which will then create a judgment in other counties where the debtor has property.
Great. And it's really important. I mean, even if we decide to do nothing else, I mean, a lot of times when we have a judgment and we're worried about collecting on it, it may be because we're worried about the financial viability of the defendant and their ability to pay. And if our client has taken or made a determination they don't want to spend any additional funds in order to try and recover the judgment, it is still worth it to docket the judgment because the fees are very nominal. If you're docketing the judgment in Wisconsin, at least in the same county in which you brought the action, it's only $5 to do that. And then typically when you're domesticating in other counties, it's also very, very nominal. So what you want to do, obviously, then is just docket the judgment because, as Deanna said, it's a judgment lien. It's a 10-year lien automatically, and you can renew it for another 10 years, at least here. And even if you do nothing else, there are times when you will get a call years down the line from someone who contacts you and says they want to know the status of that judgment and what the current balance is on it, because that judgment debtor may want to refinance or sell that property and you have a lien against that property. So I have had cases where, frankly, I have forgotten what the dispute was or who the parties were, where we have to go back to the client and say, we've been contacted. They want to know if we'd be willing to release our lien in exchange for some payment from the sale or refinance of that property. So if you do nothing else, you should still always go ahead and docket the judgment. One other method, obviously, is the best method, and that's when the defendant voluntarily decides to pay you, either in a lump sum or arranging some payment plans over time. And if they all paid voluntarily, I think we could wrap up the presentation now, but unfortunately, that's not the case. And so we have a number of tools available to us that we'll discuss today. And generally, the collection strategy is driven by information. Our job is to make informed decisions with our client to properly allocate resources toward collection with a strategy aimed at exactly that, actually collecting on the amounts that are due. So our strategies depend upon how much information our client may have before we obtain judgment or immediately at the time we're obtaining judgment, because there are some things that we can do with that information without really pursuing any of the discovery post-judgment that we typically engage in that can go toward enforcing our rights. So, the questions we would want to know when we're discussing these matters with our client are, what do we know about the debtor's assets? What do we know about where they maintain accounts, where they may own property, whether they have any vehicles or equipment that we might be able to execute against in order to enforce our judgment. And if we have answers to some of those questions, that can dictate strategy before we would go into some of the discovery that we're allowed to conduct in order to find answers to those questions. And there are a number of ways that we can go about getting some of that information, even really without engaging in formal discovery. Yana, you don't want to talk about some of those sources of information?
Sure. I guess one of the most obvious one is asking your client about what they have in their file about the debtor and any potential assets or addresses, bank accounts, anything they may have on the debtor. Oftentimes they'll have at least one address or a phone number or an email, which may still be used by the debtor or may not, but it's still best to just start with what your client has as information. There is also the credit application that the judgment debtor filed with your client in the beginning that may have some useful information. The credit bureau report may have some information on the judgment debtor. Other public records like the county treasurer, local tax assessors, register of deeds, clerk of court, probate, any licensing and regulatory authorities. If that's harder to obtain right away, but income tax returns usually have useful information about assets and income. Other financial statements that the judgment debtor may have given your client. Any CD directories, telephone directories, postal services, the Wisconsin Department of Financial Institutions, again, like may have some useful information. In Wisconsin, at least, it's pretty easy to obtain online. The Department of Transportation may have some information on the judgment debtor's vehicles. Title companies who can help with finding real estate. The Chamber of Commerce, the Better Business Bureau of Wisconsin. And if all of this fails, another tool that can be utilized is hiring a skip tracing service. A skip tracing service is especially helpful in cases in which the debtor has failed to answer or return repeated calls and emails, where the debtor cannot be even located to be served with papers. Skip tracers specialize in finding information about the debtors, and oftentimes the processes they utilize can be more cost effective than us doing it.
Great. And then, once we know where the defendant is located, where the debtor is located, maybe we know who to contact in order to pursue them. If we don't know anything really about their assets, the company's financial viability or resources, what we want to do is what we call here a supplemental examination or a debtor's exam. Other states have similar procedures. In Illinois, it's a citation to discover assets. But you want to require the judgment debtor to provide you that information so that you can go about collecting and enforcing your judgment. In some jurisdictions, including counties in Wisconsin, depending on the type of claim you have, they are required to provide that information automatically, and the county provides a form where they have to provide some basic financial information to the creditor. But in most cases, the creditor has to take some form of affirmative action to discover this type of information. In federal court, federal rules for enforcement provide that the general discovery procedures apply to a judgment creditor to aid in the execution of judgment. And so there's a number of tools we can use in order to get documents and ultimately require the judgment debtor to sit down for, in effect, a deposition or examination under oath about their assets. Again, here in Wisconsin, we call it a supplemental examination. That is usually done through an order issued by a court commissioner requiring the judgment debtor to come in and give testimony as to the nature and location of their assets. This really becomes the first step in the process because it's really, really helpful. You're able to ask generally about any assets that the judgment debtor may have or may have claim to. And when our partners come in and say, "Hey, look, I just got a judgment. What do I do now?" Or our client says, "Okay, we just got a judgment. What do we do?" This is typically the first step. Is we want to set up the supplemental examination, require the judgment debtor to come in and answer a number of questions that we can then use to dictate our further collection strategy and identify any assets that we can immediately pursue to try and satisfy our judgment either in whole or in part. That as part of that process, we can require the judgment debtor to produce a lot of information, bank account information, tax returns, bank statements, employment information, any properties they own, valuable collections, inheritances, receivables, ownership interests in other companies. I mean, the list is pretty broad. It's probably as broad as your imagination when you're trying to think of what is potentially relevant in order to determine whether this judgment debtor has assets that I can pursue. The judgment creditor can call witnesses with knowledge of the debtor's assets. So it can be officers or employees of the company. It doesn't just have to be the principal of the defendant. This includes at times the debtor's spouse. You can call the debtor's spouse in to answer questions about marital assets that may be seized in order to apply to the judgment. That is a particularly effective topic. I have examined some pretty angry spouses and have been able to negotiate payment terms even just after noticing the spouse's examination because they don't want their family involved. And I think what we'll talk about throughout is part of the strategy in trying to enforce your judgment against a debtor who is unwilling to pay or negotiate terms is really to make yourself a nuisance, and give them every motivation to make you go away by coming up with resources to satisfy that judgment. The goal with the debtor's examination, supplemental examination, is to discover as much information as possible to potentially execute against non-exempt assets to partially or fully satisfy our judgment. So what do we ask about? Basically anything we can. Open bank accounts, any vehicles they own, any valuable collections, insurance policies, investments, any personal property they may have, whether they're expecting a tax refund, again, business ownership interest. We can ask about and walk through financial statements, profit and loss statements, tax returns for any entities they may own or have an ownership interest in. Can inquire about transfers of property, ask whether anyone owes them money that maybe you can help them pursue in order to enforce your judgment. The motor vehicle one's always fun. You know, we have one of my mentors at the firm was Pat Howell, and his favorite story in conducting a supplemental examination was he was inquiring about assets of a particular judgment debtor, asked how they got to the examination that day. It turned out they had driven an expensive Jaguar to the examination. It was not it was not leased, so it was owned. There was sufficient equity in the vehicle, and so he had the court commissioner order the judgment debtor to turn his keys over to him at the location. So, I have not, unfortunately, had the benefit of that. I did have opportunity to inquire about well-to-do real estate developer who I was examining, but he was clearly well advised because he had arrived in a rather beat up van that I don't think the bank had any interest in taking to try and collect it. So it really becomes the roadmap. It provides all the information that we would then discuss with our client. It forms the basis for seeking a turnover order from the court commissioner, as I mentioned, in particular with his car. You can then use it as the basis to have a supplemental receiver appointed to assist with collection once you've identified assets that could be seized and applied to pay down the judgment. It identifies accounts for garnishment, potentially, identifies personal property and real property that would be subject to execution, and identifies potentially membership and ownership interests that could be the subject of charging orders. So it gives us really the roadmap that we would then bring and have a discussion with our client about what's the most effective strategy that we should employ to enforce our judgment. It's an efficient way to obtain a lot of information so that we're then able to make informed decisions about collection and enforcement. Yana, you want to talk a little bit about supplemental receivers and what they do?
Sure. So yeah, once we have information about assets, or in situations when the debtor is not cooperating, which happens often, appointing a receiver or asking the court commissioner to appoint a receiver can be a very effective way to approach the problem. And the primary advantage of appointing a supplemental receiver is that the creditor for whom the court appoints the supplemental receiver obtains a senior lien over other judgments, of other judgment creditors, which can be very helpful if multiple creditors are trying to recover from the judgment debtor's assets at the same time. Because unlike real property, where once you have your judgment and it's properly docketed, it becomes a lien which has priority over subsequent judgments obtained on that docketed on that real property. There isn't a similar mechanisms when it comes to personal property. So if several judgment creditors are trying to recover from the judgment debtor's, let's say, bank account, it is really a first come, first serve problem, and having a supplemental receiver solves that, trying to get to the assets first problem. So that can be very effective to preserve your priority over the assets of the debtor. A supplemental receiver basically steps in the shoes of the judgment debtor. So the supplemental receiver has the right to sell property of the judgment debtor, take possession of property of the judgment debtor, if any property is to be paid to the judgment debtor, including accounts receivable, the receiver has the right to take possession of those. The one thing that the supplemental receiver cannot do is run a business of the judgment debtor, but basically everything else supplemental that a judgment debtor can do, a supplemental receiver can do as well. Once appointed, the receiver may seek to recover all non-exempt assets that are presently in the possession of the debtor for the benefit of the judgment creditor. And the court or judge may order any non-exempt property to be applied to the judgment. If the judgment debtor is not cooperating with the supplemental receiver, the judgment creditor can seek contempt from the court to make basically the judgment debtor comply with the directive of the receiver. That's basically it. Tim, is there anything else you want to add to for supplemental receivers?
No, I think you covered that. I mean, typically what we want to focus on is, okay, now we have the information, what do we do with it? A supplemental receiver can be a very efficient way of going about enforcing a judgment, having someone tasked with really pursuing those assets. The only issue with supplemental receivers is, that we have to compensate them. And that can be either through some percentage of what they actually collect or some charge on an hourly basis. And so the discussion at that point has to be with the client in terms of how much more do they want to spend to try and enforce their rights. And that depends in large part on what assets we believe are available for collection and execution. The most common tools that we have in order to actually go about seizing assets that we've identified are either through garnishment or executions. In most jurisdictions, there are two types of garnishment. So there's an earnings garnishment or an account garnishment. Earnings garnishments are exactly what you would anticipate. Serve a garnishment action on the judgment debtor's employer. The employer must then calculate the amount of the garnishment, notify the creditor of the amount owed. Typically, there's a time limit on those. In Wisconsin, it's 13 consecutive weeks. There's a percentage as well. In Wisconsin, ours is 80% of the debtor's disposable earnings are exempt from garnishment, meaning 20% of their disposable earnings can be withheld from each paycheck during the garnishment period. Disposable income or earnings in Wisconsin just means the earnings of the debtor after deducting the taxes on the wage statement. After that 13-week period expires, it can be renewed. So it requires you to kind of continually stay on top of the judgment debtor and making sure you're timing those actions so that you're filing the second or subsequent action after or I guess to coincide with the lapse of the first. You're only allowed, creditors are only allowed one garnishment at a time. So if someone else is garnishing that debtor's wages, you have to wait your turn in line. The other type of garnishment is one that we frequently use. In particular, it's one we use when we know where the judgment debtor maintains accounts. And this is one where we would usually, if we know that information, we will do this first before doing a supplemental examination or really doing anything else. We would issue an account garnishment to a financial institution where the judgment debtor may have their operating accounts or otherwise have checking and savings accounts. The garnishee becomes liable then after the time that garnishment action is served upon them and must hold those funds in the account really until the parties have an opportunity to come into court, whether the judgment debtor has any defenses, offsets, or exemptions they can claim in those amounts becomes really the only subject of that hearing. But usually if there are funds in those accounts that are being held, once those are frozen, the court will issue an order that those amounts be turned over to the judgment creditor. And For instance, here where you have a judgment debtor that's a corporation or a corporate entity, there are no exemptions that are applicable. If you're able to time it correctly, the judgment debtor will lose possession of those funds. They'll be turned over directly from either that financial institution or whoever may be holding those funds for the benefit of the creditor. Again, timing's everything here. You always want to notify and serve the account holder first. So if it's a bank, you want to serve the bank before you give notice to the judgment debtor that you're doing this, because logically they'll just withdraw the funds before you can get to them, before they're frozen. This is also an important point, I think, for our clients who may be served with a garnishee complaint. They should take those very seriously and make sure they're timely responding to them and setting aside funds, because depending on the jurisdiction, they can become liable for either the amount they should have held, or they can potentially become liable for the full amount of the judgment owed to the third-party creditor. So when we're getting those should always be addressed timely and properly. And if we are served with them and have questions, we're happy to answer those. But they can subject themselves to liability to a third party where they might not otherwise have anticipated doing so. The other tool that we frequently use once we have identified an asset, whether that be personal property, equipment, a vehicle, even real property, is an execution. In Wisconsin, we file our executions with the sheriff's office where the property is located. And we want to specifically identify the real or personal property that we're asking the sheriff to execute against. Otherwise, the sheriff may go to the property and come back and say, well, I didn't know what you were asking me to execute against, and so he will return it as unsatisfied. Now, there are times in Wisconsin where we do that intentionally, because if a sheriff returns an execution on a judgment unsatisfied, here that is the basis for filing what we call a Chapter 128 proceeding and having a receiver appointed for the benefit of all creditors. So there can be strategic instances where we want to be somewhat vague about what we're asking the sheriff to execute against, if our ultimate goal is to file a 128. But if not, we really want to be specific, so the sheriff goes to the property, tags, removes, or holds the property that we're asking him to execute against. If there is no equity in that property, there's no right to execute against it. There's really no point in doing so, because we're not going to achieve anything for our client in doing so. With respect to personal property, there are no redemption rights for the judgment debtor to try and redeem the interest in the property. One thing to note with both real and personal property is that any prior liens in favor of any other party, including banks, remains attached to the property and survive the sale. So our sale of whatever that property may be is still subject to any pre-existing liens in that property. One method that we've used with respect to execution, particularly with respect to operating businesses, primarily in the hospitality industry, is the till tap. So you execute against that client. We've had clients before who were meat purveyors to restaurants. The restaurant was not paying the bill. We got judgment against them. The sheriff is actually authorized to go to the site and remove cash from the register during the operations of the business. And you can imagine that's a pretty compelling method to get the judgment debtor to pay attention. With real property executions, there is a redemption period. In Wisconsin, it's a pretty long redemption period, so it's not the most efficient method of recovering on a judgment. It's a 12-month redemption period after the time of sale, where the judgment debtor has the right to redeem that property. There's then another 3-month period where other creditors or mortgagees may acquire the property in the purchaser's interest. So it's actually a 15-month redemption period. But if the 15-month redemption period is come and gone and there's been no redemption, the sheriff would then execute a deed to the purchaser. And that sheriff's deed, as I said, conveys the judgment debtor's right, title, and interest to the property, subject to any other liens that may exist in that property. With Executions against real property, there are usually very detailed regulations providing the time, manner, and notice requirements for conducting a sale. And there are jurisdictional limits because if you're asking a sheriff to execute against property, if that property is located in another county, that sheriff has no jurisdiction and can't execute against that property. And that's why we want to identify where the property is located in addition to the ownership interest, because if we have knowledge that the property is located in a county or jurisdiction where we don't currently have judgment, we want to go about domesticating our judgment in those locations so that we can proceed against those properties as well.
Yes, as Tim said, oftentimes judgment creditors will need to recover from assets of the judgment debtor that are not only located in a different county, but that are located in other states as well. And to do that, the judgment creditor needs to first domesticate the judgment in the new forum. As a constitutional matter, full faith and credit is to be given to a judgment of a state court by in one state, by courts of other states, and by federal courts. And to domesticate a judgment in another state, the judgment creditor should proceed under the what's called the Uniform Enforcement of Foreign Judgments Act, or UEFGA. And once the judgment creditor records the original judgment, the new court in the new forum enters what is now a domestic judgment. The new domestic judgment is interpreted to afford the judgment creditor the same scope of protection to which the creditor was entitled to under the original judgment. What this means basically is that the judgment creditor stands in no worse position than the creditor was in the original form. And the creditor now can begin enforcement proceedings in the new state. That being said, it is the law of the state where the foreign judgment has been registered that governs the enforcement of the judgment and the remedies that are available to the creditor. Tim, do you want to talk about charging orders?
Yeah, I can. And just one quick point on domesticating judgments. That's usually a relatively easy process. You have to get, depending on jurisdiction, a triple exemplified copy of the judgment for filing in the other jurisdiction, which is a fancy way of saying it apparently needs 3 different stamps on it by the clerk's office. And then you can file it and enforce your judgment in the other jurisdiction. There's usually some time period where the judgment debtor has a right to object to the domestication. That's not an opportunity to relitigate the entire dispute. It's really just a procedural challenge to whether or not there's any technical deficiencies in the domestication of the judgment itself. One question we get a lot is, can I foreclose on someone's membership interest in an LLC or their partnership interest in a partnership? In Wisconsin, you cannot. The most you can do, and this is the case in many jurisdictions as well, is get a charging order. And what that does is it essentially gives our client, the creditor, the right to receive any distributions that otherwise have gone to the debtor by virtue of that membership interest or partnership interest in the event they're on the membership interest, but we could sale of the partner's transferable interest in the partnership. Not to us, we can't foreclose on it, but we can force and trigger a sale under the statutes. In my experience, it's not all that effective, frankly. But because I guess in particular, if that ownership interest is by virtue of their role within a limited liability company or partnership where they play a key role, and all we're allowed to do is charge against any distributions, well, they're not going to make any distributions. But it is really a nuisance, and you're interfering with the ongoing operation of the business. You're starting to pry into other ownership interests they may have that may have been unrelated to the reason you got a judgment against them. And as I said, that's a big part of our job when you have a judgment debtor unwilling to pay the judgment, is to be a nuisance, to be present, to constantly be pursuing your remedies and inquiring about assets they may have or may in the future have that could be used to satisfy the judgment. You want to motivate that judgment debtor to figure out some way to resolve the judgment and be rid of it and resolve the issue. And so, we use all of the tools at our disposal, whether it be our ability to conduct discovery or any of the other methods that we've talked about, charging orders, executions, garnishments, to motivate that judgment debtor to deal with us, to come to terms that we can actually recover on our judgment now that we have it, and where appropriate to execute against property that can be then seized and sold so I think we're a bit over the time that we had. Tried to move quickly to cover a number of topics here. I don't know if there are any questions, but happy to address any questions either now or offline.